Constitutional guarantees for the human rights of our people were one of the persistent demands of our leaders throughout the freedom struggle. The framers of our constitution sought to unite our very vast country with great diversity of languages and creeds within a common bond of constitutional justice based on the ideals of liberty, equality, fraternity, and justice. The framers of our constitution showed an uncompromising respect for human dignity, an unquestioning commitment to equality and non-discrimination, and an abiding concern for the poor and the weak. The scheme of the Constitution to realize the socio-economic agenda comprises both the justiciable, fundamental rights, as well as the non-justiciable, directive principles. Rights are defined as the claims of an individual that are essential for the development of his or her own self and that are recognized by the society or the state. These are legal, social, or ethical principles of freedom or entitlement and are the fundamental normative rules about what is allowed to people or owed to the people. Rights are often considered fundamental to civilization, being regarded as established pillars of society and culture. But the rights have real meaning only if individuals perform their duties. A duty is something that someone is expected or required to do. In fact, rights and duties are two wheels on which the chariot of life moves. Thus, any right comes with an unstated, implicit obligation to show respect for the rights of others. The obligations that accompany the rights are in the form of duties. If we have the right to enjoy public facilities like transport or health services, it becomes our duty to allow others to avail the same, which means that we ensure they are not damaged or impaired for use by others. If we have the right to freedom, it becomes our duty not to misuse this and harm others. Long before the UN Declaration of Human Rights in 1948, Father of the Nation Mahatma Gandhi stated in the Second Roundtable Conference in London that his aim was to establish a political society in India in which there would be no distinction between high class of people and low class of people, that women should enjoy the same rights as men, and dignity, justice, social, economic and political would be ensured to the teeming millions of India. The Constitution of India provides for 6 fundamental rights. First and foremost is the right to equality. It has 5 provisions from Articles 14 to 18 to provide for equality before the law or for the protection of law to all persons in India, and also to prohibit discrimination on the grounds of religion, race, caste, sex, or place of birth. Equality before law means that Constitution guarantees that all citizens will be equal before law. It means that everyone will be equally protected by the laws of the country. No person is above the law. There will be no discrimination on the basis of religion, race, caste, sex, or place of birth. The state cannot discriminate against any citizen. This is necessary to bring about social equality. Every citizen of India has equal access to shops, restaurants, places of public entertainment, or in the use of wells, tanks, or roads without any discrimination. However, the state can make special provisions or concessions for women and children. Equality of opportunity to all citizens in matter of public employment. While the state cannot discriminate against anyone in the matter of public employment, all citizens can apply and become employees of the state. Merits and qualifications will be on the basis of employment. However, there are some exceptions to this right. There is a special provision for the reservation of posts for citizens belonging to scheduled castes, scheduled tribes, and other backward classes. Abolition of untouchability. Well, this means that practicing untouchability in any form has been made punishable offence under the law. Abolition of titles. This means that all the British titles like Sir or Knighthood or Rai Bahadur, which were given to the British loyalists during the British rule, have been abolished because they created distinctions of artificial nature. However, the President of India can confer civil and military awards to those who have rendered meritorious service to the nation in different fields. Civil awards like the Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri and military awards are conferred. The Constitution of India also provides the right to freedom to all its citizens. The right is stipulated under Articles 19 to 22. 4 categories of rights to freedom include: Article 19 of the Constitution provides for 6 freedoms: freedom of speech and expression, freedom to assemble peacefully without arms, freedom to form associations and unions, freedom to move freely throughout the territory of India, freedom to reside and settle in any part of India, freedom to practice any profession or to carry on any occupation, trade or business. The purpose of these freedoms is to build an environment for the proper functioning of democracy. Protection in respect of conviction. Article 20 of the Constitution provides for protection in respect of conviction for offences. No one can be convicted for any act that was not an offence at the time of its commission, and no one can be given punishment greater than what was provided in the law prevalent at the time of its commission. Protection of life and personal liberty. Article 21 provides that no one can be deprived of his or her life or personal liberty except according to the procedure established by the law. Protection against arrest and detention in certain cases. Article 22 says that whenever a person is arrested, he or she should be informed as soon as it is possible of the grounds for arrest and should be allowed to consult and to be defended by a legal practitioner of his or her choice. Traditionally, the hierarchical Indian society has encouraged exploitation in many forms. The Constitution, however, has provisions against exploitation. Citizens are guaranteed protection against exploitation through Articles 23 and 24 of the Constitution. In case of prohibition of traffic in human beings and forced labour, traffic in human beings and beggar and other similar forms of forced labour are prohibited. In case of prohibition of employment of children in factories, there is a provision that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. One of the objectives in the preamble is to secure to all citizens liberty of belief, faith and worship. Since India is a multi-religious country where Hindus, Muslims, Sikhs, Christians and many other communities live together, the Constitution declares India as a secular state. It means that Indian state has no religion of its own, but it allows full freedom to all citizens to have faith in any religion, to worship the way they like. This right, however, should not interfere with the religious beliefs and ways of worship of other fellow beings. This freedom is available to the foreigners as well. In respect of the right to freedom, the Constitution makes 4 provisions under Articles 25 to 28. As regards to freedom of conscience and free profession, practice and propagation of religion, all persons are equally entitled to freedom of conscience and the right to profess, practice and propagate religion freely. However, it does not mean that one can force another person to convert his or her religion by force or allurement. Also, certain inhuman, illegal and superstitious practices have been banned. As for the freedom to manage religious affairs, subject to public order, morality and health, every religious group or any section, therefore, shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own and acquire movable and immovable property, to administer such property in accordance with law. When it comes to the freedom of payment of taxes for promotion of any particular religion, no person shall be compelled to pay any tax, the proceeds of which are specifically used in payment of expenses incurred on promotion or maintenance of any particular religion. As for the freedom to attend religious instruction or religious worship in certain educational institutions, no religious instruction shall be provided in any educational institution wholly maintained out of the state funds. India is the largest democracy in the world with a diversity of culture, scripts, languages and religions. This makes the protection of language, culture and religion essential. Since people take pride in their own culture and language, a special right, cultural and educational right, has been included in the chapter on fundamental rights. In Articles 29 to 30, 2 major provisions have been made. Protection of interests of minorities, which means that any minority group having a distinct language, script or culture of its own shall have the right to conserve the same. Right of minorities to establish and administer educational institutions. All minorities, whether based on religion or language, have the right to establish and administer educational institutions of their choice. Since fundamental rights are justiciable, they are like guarantees. They are enforceable as every individual has the right to seek the help from courts if they are violated. Encroachment or violation of fundamental right in our day-to-day life is a matter of great concern, which is why our Constitution does not permit the legislature and the executive to curb these rights. It provides legal remedies for the protection of our fundamental rights. This is called the right to constitutional remedies stipulated in Article 32. When any of our rights are violated, we can seek justice through courts. We can directly approach the Supreme Court that can issue directions, orders, or writs for the enforcement of fundamental rights. The 86th Constitutional Amendment added the right to education by introducing a new Article 21A in the chapter on fundamental rights in 2002. It was a long-standing demand so that all children in the age group of 16 to 14 years and their parents can claim compulsory and free education as a fundamental right. But this remained meaningless and could not be enforced until 2009, till Parliament passed the Right to Education Act in 2009. It is this act that ensures that every child between 6 to 14 years of age in India goes to school and receives quality education as his or her right. This was because the right proved to be a hindrance towards attaining the goal of socialism and redistributing wealth equitably among the people. The right to property is now a legal right and not a fundamental right. Restrictions may be put on the right to freedom of speech and expression in the interest of the sovereignty, integrity, and security of India, friendly relations with the foreign states, public order, decency or morality, or even in relation to contempt of court, defamation, or incitement to an offence. Right to assemble peacefully and without arms may be restricted in the interests of the sovereignty and integrity of India. The right to form associations or unions may have restrictions in the interests of public order. The right to move freely throughout the country of India and to reside and settle in any part of India may also be restricted in the interests of the general public or for the protection of interests of any scheduled tribe. Right to practice any profession or carry on any occupation, trade or business may have restrictions in the interests of the general public. The doctrine of severability protects the fundamental rights enshrined in the Constitution. It is also known as the doctrine of separability. Article 13 says that all laws enforced in India before the commencement of the Constitution and inconsistent with the provisions of fundamental rights will be void to that extent of inconsistency. This implies that only the parts of the statute that is inconsistent shall be deemed void and not the whole statute. Only those provisions that are inconsistent with fundamental rights shall be void. Fundamental rights can be suspended during a national emergency, but the rights guaranteed under Articles 20 and 21 cannot be suspended. The application of fundamental rights can be restricted in an area that has been placed under law or military rule. Human rights are universal, fundamental and absolute. Universal because they belong to all humans everywhere. Fundamental because they are inalienable. Absolute because they are basic to life. The basic difference between human rights and fundamental rights is the scope of acceptance. While fundamental rights have the scope within a country, human rights are accepted worldwide. Human rights which could not find place under the fundamental rights have been included in the chapter on directive principles of state policy. Moreover, keeping in view the importance of human rights, the National Human Rights Commission was founded in 1990